Okay.
So we have this. Well, first of all, it's Sam Thurman and Cliff Stewart. Thank you for joining us. And I'd like you to tell us the story of this software. It's a software company, right? And product that was an innovative product, got the attention of the Defense Department, and at the end of the day, 6 of the members of the company get prosecuted because the company owed some people money, federally prosecuted, and then end up going to prison. Could you tell us about it? It's the IRP 6. We're talking about Gary Walker, David Banks, Clinton Stewart, Kendrick Barnes, Demetrius Harper, and David Zerpolo.
Well, Don, thanks for having us on your program. This is Sam Thurman. As far as the IRP 6 are concerned, yeah, you're absolutely right. The gentlemen were executives in a software development company. Software development company was IRP Solutions Corporation, and they were developing software for law enforcement. And it was a software that would help law enforcement to automate the way they do investigations for all practical purposes. Bringing them up to the technology age, if you will. And the company was started in 2003. And just a quick overview. In 2005, they were accused of wrongdoing. Now, basically what happened, Don, is the company had incurred debt like any other startup company, and that debt was criminalized. And so in 2005, the company was raided by the FBI, and then between 2005 and 2008, 2009 time period, it took the government 2 federal grand juries in order to get an indictment. And the case went to trial in 2011, and that's when the gentlemen were convicted in 2011. Now we can drill down further into a lot of the details as to what occurred during that time as well.
A couple things strike me from this. The first is, I guess maybe we could get a description of the nature of the debt. Are we talking about withholding, like tax withholding or things like that, or are we talking about debts to third parties?
Yeah, we're definitely talking about... Go ahead, Sam.
Go ahead, Cliff. No, go ahead, Cliff.
No, I was going to say, this is Cliff Stewart, and I was going to say, Don, we're talking about debt absolutely to third parties. We're talking about corporate to corporate contract debt. There are staffing companies involved that help to staff certain IT professionals for our IRP solutions to develop their Silk software. Now, a lot of times, what has been asked, well, why did this company use so many staffing companies? Well, when you look at IT staffing, when you look at development of software for law enforcement, you look at the different aspects of that software. You're talking about security. You're talking about a secure framework that can collaborate and communicate all across the country to all federal law enforcement agencies. You don't just go to a staffing agencies that says, hey, we're looking to staff some telemarketers. We're looking to staff a girl for the front desk. We're looking to staff somebody to take notes during a meeting.
You don't go to Manpower, right? Yeah, you don't go to Manpower for that, right?
Exactly. You don't go to Manpower and say, look, I need 20 people to sit on the phone and call up and try to give people credit cards at 25% APR.
Yeah, right,
That's not what we're talking about.
Right.
We're talking about IT professionals that have to have security background, that can pass a government security check, that know software development and system architecture to their nth degree to build something like this. So you have to pick and choose. And when you go to a staffing company and say, I need this cybersecurity architect, do you have somebody who fits the bill? You say no. They say no. You say, okay, well, I have another list. I have this person on here. And you get down to, where you say, okay, well, I need somebody like a database developer. They say, yeah, we can provide you that. So you go through the gambit to say, I need all these agencies to provide me with these different skill sets. So this is contracted work that says you provide me, you go headhunting for me, you find the person that can do the work. And then what is really crazy about this, none of the money passed through the hands of the IRP Solutions executives. These are staffing companies who are paying their contractors. They cut the check to their contractors, not to IRP Solutions. Right. So this is the debt. Yeah, and they've never denied that they went in debt trying to build this product for Department of Homeland Security, for New York Police Department, and several others. But it's debt. It's debt between two companies. And the irony of this all is when one of these staffing companies presented the situation to the FBI up in Denver, Colorado, the response from the FBI was that this is a civil matter. You need to try to take this up civilly and basically get your money back. This is a debt issue. So then how then did it get criminalized and go to federal court? Makes absolutely no sense.
Right. So let me be clear. First of all, we're talking about a corporation. That's where the company that you worked for is a corporation. The entities that you're contracting with are corporations. The nature of the debt is the kind that can be discharged in bankruptcy, and there's no criminal liability attached to bankruptcy court unless there's fraud. And then the FBI themselves saying essentially to the people making the complaints, look, we're not in the debt collection business. Go to civil court and and sue like you're supposed to. And if you wanted to, again, absent fraud, generally you fold the corporation up, and that's the end of it. Whatever assets are in the corporation are available to the creditors, and that's the end of the story. So how do you end up in federal court facing criminal? How do these guys end up in federal court facing criminal charges?
And that is.
And Don, if I may, and just to kind of even more so add to the unusual abnormalities in this case, two things I want to point out. I mentioned, and this is Sam again, I mentioned that the business was raided in 2005. Yeah, well, prior to that raid, IRP had ongoing visits with the Department of Homeland Security. The Department of Homeland Security actually reached out to IRP Solutions and said that we understand that you're developing software that's going to fit the bill for things that we need to do and that we need to have happen. And at that time, the Department of Homeland Security was a new agency that was tasked with pulling together all the other federal law enforcement agencies under one umbrella so that another 9/11 would not occur. Right. So now that, being said, IRP was also engaged in several meetings with NYPD. So you're talking two of the largest agencies in the world. And so prior to this 2005 raid, the FBI agent who executed the raid, along with 22 other agents, had actually had gone to these agencies to validate, is IRP Solutions a real company? Do they have a real software? Is this legit? What's going on? At the same time, IRP had retired federal agents working as consultants for them who had vouched for the legitimacy of the software and the legitimacy of the company. Right. Agent John Smith persisted and still got moved forward and got a judge to sign off on a search warrant stating that IRP was a purported software development company. Don, that is getting a search warrant and executing a raid on a company under false pretenses. Right. You presented to a judge that this company is a front, yet you already know that it's not a front.
Well, you have supporting that, you have two facts. One, his personal knowledge of the corporation's ongoing business, and two, the certificate of incorporation filed in whatever state you incorporated. So it moves from purported to a fact, for the purposes of inducing a warrant. There's a couple of things before we move out of this part of it that I want to touch on. Number one, Homeland Security was created ostensibly, purportedly, to coordinate the efforts of local, regional, and federal policing for surveillance purposes to avoid another 9/11. That was the legislative intent in creating it. And that was the public relations justification for creating this thing that was otherwise an offense to the political system in this country. It's an unusual step for the United States. And the essence of that creature would be communications, which means software. Integrating these functions would require software that would be new in style and design because it's a new task. So
right.
In the process of doing this, I assume that what you're doing is sort of foreshadowing the creation of this department by doing scenarios of various activities that they would conduct and finding ways of doing those things efficiently with the computers. So how is it that you guys essentially are helping design DHS and you move from that to being criminalized and railroaded in the first part? And secondly, who ends up with the contract?
Well, Don, based on to answer your question, it basically points to the fact that, and you're absolutely right as far as the intent of why DHS was established. And when you look at the failed initiatives by other major defense contractors in their attempts to help the Department of Homeland Security and the federal government establish some means of communicating via, technology and software and so forth. After 9/11, there was the 9/11 Commission. The 9/11 Commission report clearly calls out the fact that our nation was sore lacking. I mean, there was no communication between state, federal, and local law enforcement as far as sharing information and collaborating on information. It wasn't so much that these various agencies may not have had various components of information that could have been helpful, but they were not sharing that information. So now back to your question. As far as making that happen, there were failed initiatives. And I'm going to let Cliff speak to this, but you basically have over $1 billion that had been wasted on initiatives that were supposed to help to establish this kind of communication and collaboration and information sharing that did not work. We're talking smoke and mirrors. So there was a lot of money on the table as to, people did have something to gain by pushing a small company like IRP Solutions out of the picture. That being said, I'm going to let Cliff share a little bit more information as to the companies that failed at doing this.
Yeah, please.
Sure, Sam. If you look back, Don, to 2005, the FBI director, Robert Mueller, he had to stand before Congress and give an account to Congress why the FBI paid one company, SAIC, which was a software development company, over $425 million for the VCF software, which was the virtual case file, which was supposed to do for the FBI what DHS was built for, to collaborate, locally, regionally, and federally, all of their units, bring together what was going on with the CIA and NSA, bring that information together. Well, SAIC built something. It didn't work. Director Mueller had to stand before Congress, and he basically had to tell them, yes, we spent $425 million of taxpayer dollars, and we have nothing to show for it. The project failed. We have to, in essence, start from scratch.
I mean, I remember in this time frame.
That was shot number one.
Yeah. To
replace the virtual case file that came up. Yeah, and I remember looking at that and thinking, how do you stand in front of America, its people, its citizens, its government, and say, we just wasted pretty much $500 million and whatever. We need another right, 800 million.
Right.
Yeah, we need another 800 million to build the replacement software, which they dubbed the Sentinel Project. Well, the Sentinel Project in 2012, they claimed that they completed that. But when you read the Inspector General's report about the Sentinel Project, the Inspector General for that project says if this software is implemented, that it would basically open up America to more terrorist attacks, but on a cyber level. So it's not secure. The information would be leaked, and all of our law enforcement information would basically be out there for cyber terrorists to take. So they couldn't implement that. So you're looking at a tune of about $1.2 billion that was spent on these two projects. Then, to make it even worse, you say, well, if IRP solution executives were indicted, convicted, and put in federal prison for having debt, for writing contracts with other companies, going into debt, and not pay that debt because there was interference with commerce by the prosecutor. We'll leave that for later.
Right.
They go to federal prison, and now you have these other two companies, SAIC for the virtual case file and Lockheed Martin for the Sentinel project. Which of those executives were even indicted? What type of charges were brought against any of them? Nothing, none whatsoever. It was written off, and nothing has been done to those corporations. Then to answer your second question, well, what software got implemented as far as DHS's, their creed for being able to bring all this together? They had the consolidated enforcement environment, which was the entire project that says we'll bring all of these federal agencies together for law enforcement. Well, after IRP Solutions got raided, DHS was told do not do business with them. They're under investigation. Well, prior to that, probably 2 weeks before the raid on IRP Solutions, DHS was sent a quote by IRP Solutions for the confidential informant module of the software, which would have been what DHS needed. That was for $100 million. 2 weeks later, the company gets raided after, and I mean, this is after going back and forth, doing customizations for DHS and them saying, we like what we see. Now let's get a quote and see what it'll take to implement this. Well, after the raid on IRP Solutions, the whole consolidated enforcement environment project went belly up. They didn't have anybody else that had anything viable to offer. So the country, and if you look at the 10th anniversary of the 9/11 Commission report, they say the country is more vulnerable now than it was on 9/11/2001. So not only do you take these men that were in debt and you lock them up in federal prison, they had the answer to the question for DHS, and they haven't been able to implement anything substantial since. And the country is still, now in a worse position because they've implemented absolutely nothing. They even said the Boston Marathon bombing. We talked to one of the committees, the Homeland Security Committee in Congress, and they said that they feel that the Boston Marathon was for the same reason. It was allowed to happen for the same reason that 9/11 was allowed to happen. There was no collaboration between these federal law enforcement agencies. They saw these two brothers. CIA, NSA, FBI had different information on them. If they had brought it together, they would have been able to see this is what they're planning to do. No collaboration software. They weren't able to do anything, and here we have more American lives lost. And so that's what happened with this situation.
Let me ask you a question. Oh, go ahead.
And Don, I was just going to say, if I may add to just one comment to what Cliff said regarding our state of affairs now, and like he mentioned, with the 10th anniversary of the 9/11 Commission report and the Bipartisan Policy Center, actually, they state that in their 10th anniversary report. They state that we are no better off than September 10th. So that is a sad state of affairs to say that we are no better off than September 10th. And they say that in some cases we are worse off from a perspective of cybersecurity, that the situation is even worse.
And not for nothing. With all of that, you've had massive spying on the entire population going on, supposedly to prevent these things. And billions, you just described $1.2 billion on this specific project. And I remember at the same time that the director of the FBI was being grilled about costs, that Rumsfeld, Representative McKinney, had Rumsfeld wondering where like $1.5 trillion that had gone through the Department of Defense for other contracts was, that they paid for things that they didn't get. So is it possible that they're using your software and just not paying you for it?
That seems, Don, like that would be the case, because when they came in, just to go back to the raid a little bit, they came in and they said, we come in, the search warrant says we're looking for financial documents and correspondence between these staffing companies and IRP solution executives. Well, there's two issues there. Issue number one, if you're looking for correspondence between two parties, you're already in cahoots with one party, being the staffing companies. If that were the case, why do you need to come to IRP Solutions to see the other? You have the back and forth emails.
Right.
You have the contracts. You have the timesheets that were faxed in. You have all the hours. You have the contracts, the business to business contracts. You have all that from the staffing companies. Why would you need to come raid a business when you could have kept that part of the operation, quote unquote, covert, and says we have the paperwork from the staffing companies.
Right.
Second part of that is that when they came in and they said we're here for the financials, the IRP executives put a filing cabinet in the middle of the floor that was already marked financials. Said, there you go, take a copy of anything you need out of that filing cabinet. Well, what they did instead is they went to every computer in the building. They imaged every computer. I'm talking from the janitor, the facilities manager, security guards, everybody's computer, the developers, they took development notebooks, they took drafts of architectural documents. They copied every server in the server room. And so when we look at it, we're like, are you guys here trying to basically some type of way compile the software by taking images of every computer in the place? Is that what you're really trying to do instead of getting financial documents, which are over here in the executive area? You're not going to have a financial document on the janitor's computer. That makes absolutely no sense.
Or the developer.
Nor the developer, absolutely.
More specifically.
And
so what they're doing is they have the wherewithal to reconstruct every step that you guys took in developing the software in their possession.
Right, that's what they thought that they had. But Gary Walker, who was the main architect, and this is his brainchild, he had not, and we had constantly, myself, like I said, I was the manager of IT services. I kept saying, hey, Gary, if you need me to get you proper archives of the software, of the different, the artifacts, the documents, I need you to put everything in my.
Hello?
I'm still here, Don.
I think we just lost him.
Liz, Gary never brought the software into the office. He never brought the software.
Cliff,
yes.
Cliff, you dropped out for about 20 seconds,
Yeah,
so you might want to kind of rewind a little bit on what you were just talking about.
So you had asked him to properly archive it, and
right. We asked him to properly archive it. I said, Gary, I need you to bring all of the source code in, so I can archive it. We can have it in one centralized place, and we can back it up. We can have it with our nightly backup, so when things change, I can capture that change. Well, he never brought that in. It worked out great for IRP Solutions because then when the FBI came in, they imaged all of our computers. They did not have the source code. Therefore, they could not what's called reverse engineer the application and basically get their hands on it and be able to modify it and change it to what they wanted it to be.
And Don, if I may add also, you have to also keep in mind that the Department of Homeland Security was still in a position of not really knowing what they wanted. So the Department of Homeland Security had provided to IRP Solutions various operational scenarios, whether it dealt with, border patrol, sea patrol, any type of scenario that they may encounter. They had provided these scenarios to IRP, which is a key point also because when they provided that, they actually gave it to IRP and under the auspice of for IRP Solutions eyes only. Right. So that was number one. They really weren't sure what they wanted other than the fact that we need something that will allow us to handle these type of scenarios. Number two, in the September timeframe of 2004, again, pre-raid, in the 2004 timeframe, the federal government had what they call an industry day. I'm sure you know what that is, Don, but for your listeners who may not know what that is, industry day is when the federal government calls in all of the contractors who may be able to do something to help them meet a particular need. And they kind of do a dog and pony show and say, okay, here's the next greatest thing that's coming. Here's what we are asking you as defense contractors to produce for us. And, put your best, ideas together and then do a proposal. Well, during this industry day, IRP Solutions was invited to this along with all of the other like top 100 federal contractors. Lo and behold, the presentation that the federal government put on was basically what IRP had presented to the federal government to say, in so many words, if we were to take something on like this, here's some things you need to consider. We would do this, 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 and this. But like Cliff said, it was done in a manner that did not, convey the technology, what's under the hood. Exactly how are you going to do this from a technological perspective? How are you going to do this from a software perspective? But it was kind of weird to see what IRP had presented to the federal government. The federal government took and turned it around and presented it to everyone else and said, hey, here's what we're looking for. And then in some of the water fountain conversations, the hallway conversations during the same day, certain representatives from the Department of Homeland Security was telling other defense contractors, if you want a piece of this, then there is a company. There's IRP Solutions. They already know what we're looking for. You might want to try and get into a teaming agreement with them. And sure enough, these companies started calling IRP Solutions and trying to negotiate teaming agreements.
So what happens basically is there's this big chunk of money, $100 million, you guys are bidding for it, out there for this contract that you can meet, they can't meet. Some of them have been paid to do it already and haven't performed. And suddenly the government takes as much of your work as they can lay their hands on. They thought they had everything, probably, and they prosecute. So let's talk about the court case.
Well, and just one point of clarification, that $100 million was only for one module of the software. The IRP, at the time, the IRP solution software had 18 modules. And here again, I would have to direct your attention and the attention of your audience back to the 9/11 Commission report. And folks can they can check it out. But the 9/11 Commission report specifically called out the lacking approach and the ability with regard to handling confidential informants and how to, again, sharing information, collaboration, but information that's coming from confidential informants. That is the first module that the Department of Homeland Security zeroed in on with IRP Solutions. So you have the 9/11 Commission report saying you guys need to do something about this. Department of Homeland Security saying, hey, IRP Solutions, we see you got a module that handles confidential informants. Right. What is it going to cost us to do that? Right. So that was only for one module.
And from there, of course, you've got your foot inside, and whatever
Absolutely.
Other modules come out, they're going to have to interface with yours, which means in one way or another, even if somebody else gets the contract, you're involved.
Absolutely.
And just for folks to keep something in mind, remembering a little history, the condition on 9/11 was such that NYPD couldn't talk to NYFD on the same radios.
That's right.
Wow. So, okay, so now they raid and then they try to get indictments twice. They go to the grand jury twice and finally get an indictment. What the charges are based on these financial transactions with the temp agencies, basically, right? That's it?
Yes, that's it. Mail fraud and wire fraud, basically because they're saying, well, you guys basically went into a contract with these staffing companies and you didn't pay them. Well, true, but that is not fraud. That's called debt.
Right.
That's called corporate debt. Right. It happens every day, especially with small businesses trying to ramp up their product.
Right. So those are the charges. So the wire fraud has to do with we did stuff electronically back and forth with those vendors, and the mail fraud has to do with where it was correspondence through the mails with those vendors. And so if it was a fraudulent transaction, then they say that you communicated with them this way, it's that kind of fraud. You communicated with them that way, it's that kind of fraud, right?
Right. And Don, the first grand jury, which occurred in the February-March timeframe of 2007, Dave Zerpolo, who is one of the IRP executives who happened at that time to be called into the grand jury. And he was told under no uncertain terms that you are not a target of this investigation and so forth and so on. So, he gets called into the grand jury. He takes with him verifiable documentation that shows how IRP Solutions was doing business, how they conducted business, who they conducted business with. And he asked the grand jurors, I have information here. Do you want to see it? Now, obviously, the prosecutor is not expecting anything like this to happen.
Right.
That grand jury got it right. They said, yeah, we want to see this.
Right.
And they looked at it and they came to the conclusion as what we are saying. This is corporate debt. Why are we even listening to this? And one of the grand jurors even went to the extent of saying that, and asked a question. So is the federal government telling me as a private citizen even that if I don't pay my credit card, debt but I'm corresponding with the credit card company, am I now committing fraud and am I, liable to be prosecuted under mail and wire fraud because I didn't pay debt? And so that's when that first grand jury is like, no, this is debt. 2 years later, the prosecutor comes back, presents to another grand jury. He only calls one witness, an FBI agent, and that grand jury returned an indictment. The first grand jury had several witnesses who clearly laid out what happened. The second grand jury came back, and Assistant U.S. Attorney Matthew Kirsch only called one witness, being FBI agent Robert Moen. And Robert Moen, obviously, he's going to tell the story however the prosecutor wants to tell it. And if that's the only story the grand jury hears, they returned an indictment.
Yeah, that's a ham sandwich grand jury proceeding, right?
That's the ham sandwich grand jury.
Right. Okay, so then they go to trial. There were some irregularities there, right?
Oh, yeah, gosh, Cliff, where do we start?
Go ahead.
That's one word you can use, but when you look at what happened during the trial, one of the main issues that we look at, we'll just stick to the things that came up on appeal. So what happened on appeal? They had a Speedy Trial Act violation. They had a refusal by the judge to allow expert testimony, which is a Sixth Amendment violation, the right to present their evidence. Then they had a Fifth Amendment violation, which is their right against self-incrimination by any defendant based off the Constitution. Well, we'll deal with the Fifth Amendment violation. The prosecutor, Assistant U.S. Attorney Matthew Kirsch, said that his case in chief was going to last about 3 weeks. Well, a week and a half. Could you say that again?
I'm sorry, you dropped out for a minute. Could you say that again? Start with the prosecutor.
Okay, the prosecutor Matthew Kirsch, up in Denver, Colorado. He said that his case in chief was going to last for 3 weeks, and he ended up resting his case in a week and a half. Well, obviously that leaves the defense in a position where we have to now reschedule our witnesses to get them here to be presented. Well, a lot of the witnesses were coming from DHS and NYPD, Eastern Seaboard. So you're looking at flight arrangements, you're looking at hotel arrangements, you're looking at time off work, right, all these things. So when the defendants tell the judge, look, we need to deal with the schedule for our witnesses, the judge, instead of saying, okay, we can take a recess until, maybe we'll give a day or two until you guys can hash this out, she starts to, basically rebuke them. You're going to have your witnesses here. You should have accounted for the fact that, things can go faster. And they're telling her, well, it's the prosecutor ended his case a week and a half early. We had this schedule laid out. We need time to readjust the schedule. So, day after day, she continued to admonish them about this. And then they got to the point where you're talking about, and this is what is so crazy, Don, you're talking about between one witness and another, a 45-minute window that she would have had to tell the jury, you're going to have to wait for 45 minutes for this other witness to get here. Instead, she calls a sidebar conference and tells the defendants, either one of you take the stand or I will rest your case for you.
Whoa.
Yeah, exactly. That's where pump your brakes and let's go back and say, what did you say, Your Honor?
So what the judge said was, since your witness won't be here for 45 minutes, unless one of you waives your Fifth Amendment rights and gets up on the stand, I'm going to, rest your case and the jury's going to find for the other side.
There you go. Well, bingo.
And Don, a just cause has gone through and combed through the transcripts, and on at least 8 occasions, Judge Christine Arguello made comments to that effect. I mean, I can quote you where she even says here that if you don't have witnesses, I'm going to consider the defendants to have rested their case.
And this is happening in front of the jury, right?
That is in the transcript. Yeah. I don't know if that was in front of the jury or not. Do you recall if that was in front of the jury, Cliff?
I don't know. That may have been at a sidebar conference or
out of the hearing of the jury.
Right.
Yeah.
Now, while we're on that, we're talking about transcripts. There's a gap, like a whatever her name was, Rosemary Woods style gap in the trial transcript. Correct, about some very key discussion that took place with the judge.
Yes, this sidebar where the judge makes this statement that one of you defendants will have to take the stand or I'll rest your case. This is nowhere to be found in the trial transcript. Now, the court reporter, Darlene Martinez, has actually been queried by the appellate attorney. Where's the transcript? The court reporter's supervisor has been queried by the attorney. Where's the transcript? The clerk of the court, basically the manager of these two people have been queried. Where is the transcript? They've come back with, the court reporter said it's up to my discretion to deliver it. The supervisor said it's been destroyed. And then the manager says it's no longer available. Well, all 3 of those answers are wrong compared to the court reporter's act, where the court reporter has to take not only the transcribed, finished transcript, the one that's in English words that everybody can read. She also has to take her original shorthand and any notes that she takes and present those to the clerk of the court no more than 90 days after the proceedings have been rested from the case. Those have to remain in the clerk's office for no less than 10 years. So all of them saying it's up to my discretion to release them, and that's not true. That's breaking the law. For them to say they've been destroyed, nope, that's against the law. They're no longer available, that's against the law. But who has the discretion, who has the jurisdiction over court reporter Darlene Martinez, but Judge Christine Arguello to say, I will hold your feet to the fire until you present this transcript. Obviously, she never does. The defendants asked day after day, Your Honor, we've asked for that transcript of this sidebar where you violated our Fifth Amendment right. Obviously, she says I did no such thing, but he'll be provided the transcript at the end of the day. They come back the next day. We're still looking for that transcript. Well, I told the court reporter to deliver it to you. Come back the next day. We're still looking for that transcript. All the way up to the end of the trial, that transcript was never provided, and until this day, it has never been provided. And you look at what Judge H. Lee Sarakin, who was a retired district and appellate judge, he says, he wrote 4 articles about this. We also had him on our radio show where he made comments about this situation. And he was talking about the appellate court based off that missing transcript. And he said that I think the appellate court would do one of 2 things. They'd either order that the transcript be produced or they'd have to reverse. And he says, quote, it baffles me as to why anyone would deny that motion. It's inconceivable to me that the judge would say, no, you can't have the record of this trial. So here you have an appellate judge and a district judge, retired, obviously, but who says this.
You're dropping out.
This makes absolutely no sense. How does a judge say you can't have your transcript, especially the piece? Oh, I'm sorry. Can you guys hear me?
Yeah, now we hear you now. So take that part again.
Okay, so this retired appellate judge, H. Lee Sarakin, says it makes no sense that a judge would not deliver any portion of the transcript, especially a portion where it's accusing her of an egregious error, meaning this is something that you broke a constitutional right or you broke the law during this trial, why would any judge deny that? It makes no sense. But until this day, Don, that portion of the transcript is nowhere to be found.
Is it possible to subpoena the court reporter in a civil action, say for wrongful prosecution or something, so that you can put the court reporter on the stand and ask what was said, and then require her to bring her documents to the deposition?
I'll let you have that one, Sam.
Well, Don, on that, a Just Cause did actually file a lawsuit, a civil lawsuit against court reporter Darlene Martinez to deliver the transcripts. Now, the lawsuit was actually initially filed in state court. Then the U.S. Attorney's Office intervened, snatched the case from the state courts, pulled it back into the federal system, and basically announced that their office was going to represent court reporter Darlene Martinez in this case of the missing transcripts. Now, correct me if I'm wrong, Don, but the Department of Justice, the FBI, the U.S. Attorney's Office, and so forth, they're chartered with investigating and maintaining and upholding the law. If a person breaks the law, you're not supposed to represent them. And that's what we were saying. Okay, this lady broke the law. She violated the Court Reporters Act. She did not deliver transcripts, which are supposed to be made available for 10 years. So that even adds to the fact that this stinks it stinks in the sense that someone is covering something up. Why would the federal government step in to represent someone who, as far as delivering the transcripts? Now, this was a transaction with the court reporter who at this point was acting as a private citizen, because the way their laws are written and the way their rules are written,
they're hired. Okay,
she's representing the federal government as a federal employee as she is doing the transcribing. Right. But if you order transcripts outside of that, you're making a deal with her as a private person. We wrote a check out, and Cliff, what was it, $9,000?
Very close to 10.
And so the check was written to Darlene Martinez. The check was not written to Uncle Sam in Washington, D.C. at the federal government. Right. The check was written to Darlene Martinez. She violated the law as a private citizen. So, yes, we did file that lawsuit. When it got snatched into federal court, Judge R. Brooke Jackson was the presiding judge. And Judge Jackson, even in his order, states, even though he dismissed the case, and that's why we say, where do we start? This thing has so many irregularities, but Judge Jackson dismissed the case. But even in his order, he says there is no dispute that something is missing and that something was said at that sidebar that is not captured in the transcripts, and the transcripts are not here. Now, Judge Jackson even went and supposedly pulled some documents and some records from the clerk's office, but even those has a big gaping hole in it. And if we were sitting down next to you, Don, we would show you where there's this big time lapse there that everyone, even up to the appellate court for the 10th Circuit, has ignored that big elephant sitting in the corner. Yet we have 6 men that have been sitting in prison now for over 2.5 years.
And Don, just to add what Sam is saying about, what Judge Brooks Jackson brought about, we also have Judge Arguello, the presiding judge. She makes a statement, and it's in the transcript, where she says, there is something that I said that does not exist in the transcript. What clear evidence do you have to have that something is missing besides the judge saying, I said something, it's not in the transcript? We have no idea why it's not there. And Judge Sarakin says that, why is it that the court reporter has never said why that portion is missing? And why hasn't the prosecutor, Matthew Kirsch, written an affidavit as to what he heard during the sidebar. Why has Prosecutor Sanitas Hadra not written an affidavit as to what she heard at the sidebar? It is their duty as agents of DOJ to say, and I'm here to uphold, right, and officers of the court to uphold justice, not just to get into a conviction. But they will not speak to the issue. But the fact that the judge will not, how do you say there is something that I said that doesn't exist in the transcript, but it's not missing? Then what do you call it? You want to use a different word? Do you want to use the definition of missing as in not there? Well, that's what you said. Either we use the word or we use the definition, but the meaning is exactly the same. It does not exist.
Now, I have another question. The U.S. attorney that decided to intervene and defend the court reporter against that action, is this the same U.S. attorney's office that prosecuted the case, whose case might be swept aside if the record shows what you said and ends up being exculpatory?
Absolutely. I mean, this is John Walsh's office up in Denver, Colorado. They step in to, like Sam said, put their umbrella of protection over the court reporter. Now, granted, it was a different prosecutor, but they're co-workers. They're in the same office.
Yeah.
And so he makes the statement that, I mean, right there in the record, in the scheduling conference with Judge Jackson, the prosecutor makes the record, if this is brought out, this will reverse the conviction of these 6 defendants. Now, how is that a prosecutor is looking for justice if he's not dealing with the fact that we must bring this out if it'll reverse the conviction? But he's saying, please, judge, don't make us bring this out, because then we'll have to go back and we'll have to decrease our conviction rate from its 98%. Right. This is an atrocity of justice. And even when Judge Jackson asked him, well, if these defendants felt that they were compelled in any way, even if it weren't the exact words that they say that the judge said, if in any way they felt like they would have to take the stand or lay down their Fifth Amendment right, he asked the prosecutor, would that be justice? And the prosecutor answers him and says, no, Your Honor, it would not. So then, if that would not be justice, then how is it that your office is then upholding justice?
Yeah, right. All right, let me just see if I can summarize this correctly. DHS identifies a need for software to help it perform its charter, basically, to coordinate activity and information between the various police agencies around the country from the bottom to the top, which they identified and was identified by the 9/11 Commission as being a need. They put out money twice, $500 million and $700 billion, and don't get a product. This firm produces the product. It sends the first or good parts of the first module and has discussions back and forth for modifications with DHS. The feds come in and raid the place and prosecute people for civil action, for civil offenses, if they are in fact proven to be offenses. And at the trial, which when they're given a schedule that the prosecution will lay out 3 weeks, and so the witnesses being pulled from all over the country by the defense, scheduled for the beginning from week 3 out, instead have to be moved at the last minute, a week and a half forward. As they attempt to do that, the judge says, if you miss 45-minute windows on these witnesses, one of you or some of you have to surrender your Fifth Amendment rights. The record of that has disappeared. These guys are all in prison, and a civil action attempting to force the record to be made whole is dismissed, I assume, on threshold grounds, standing or some other thing, and the merits never touched, while the court reporter who has knowledge of what's missing is insulated from the proceeding by the same office that prosecuted the case. Do I have it right?
That's it. Now, that summary, listening to that, just there's not many words that I can use that would explain the disdain that the taste that's in my mouth for the judicial system with your summary of that. And I've been dealing with this case for 10 years, since 2005. And to hear that summary from someone new to the issues, but which see the the facts on the table, for you to come up with that and to hear that, it speaks to our judicial system that how.
You dropped out again. Hello?
Cliff, are you there?
Hello?
It's
Cliff?
Yes.
Cliff, it speaks to our judicial system. How? That's where you were.
It speaks to our judicial system how we don't have the right to accuse any other country of their human rights issues, of their their criminalization of non-viable issues. I mean, they say, hey, somebody made a statement against the government. They put them in prison. They ostracize them from society. But we, as the American judicial system, say you go into debt and we lock you up in prison. And then we give you a term. We give you, these men, the IRP6, have sentences of 7 to 11 years for debt that they incurred trying to develop, market, and sell a product that was full.
You dropped out again.
Yeah.
Hello?
Come right back.
Cliff? Oh, Cliff.
He's out. He's hanging out there longer this time.
Yeah.
Well, Cliff, are you back?
Well, looks like we lost him. So, I mean, there's
I'm back.
Okay. So, yeah, you say market and develop is where you dropped out.
Right, and they're trying to market and develop and sell this product, and they get 7 to 11 years in federal prison because of the debt that they incurred trying to help their country. Yeah. That speaks to the human rights issues of America, that there are these subliminal issues that are behind the scene, that are hidden from the rest of the world, and even our own, the citizens of America. It is an atrocity. And to hear you summarize it and just lay it out, in 45 seconds, 1 minute, it says, how does something like this happen in the American judicial system and we actually call it justice? Who are we to speak to the issues of the rest of the world when this is the way that we incarcerate our own citizens, our own brothers?
Can I just say something else? Because there are two other facts that I didn't mention and that we haven't discussed. Well, we collaterally discussed one. So this is a startup company that's not one of the established defense contractors who generally get to feed, particularly at military and police contracts. And they tried to feed, and they ate, but there was no nutrition. There was no give back. They didn't come up with any actual product. And so you have, the big guys behind the scenes that pull the levers, wanting the contract, and they have you guys delivering on it. You have that aspect of it. And the other aspect of it is out of the 6 convicted members of the firm, 5 of them are black.
That's right. And we look at that and we say, well, if 5 of them were white and 1 were black, would they have gotten the contract? If all of them were white, would they have gotten the contract? Would they not have gotten prosecuted, and would they be in federal prison? I mean, we're doing a exercise for some of the members of Congress that have asked us as a just cause to, because the sentencing disparities is a real big thing in Congress right now.
Right.
And so they've asked us, hey, check on minority sentencing based on sentencing of Caucasian Americans.
Oh, please just go to any prison, right. Or any county jail or any courtroom.
It's like, sure, we can get you those numbers, but we could take a picture of the prison yard and give you a snapshot of what's going on.
Any prison yard, right.
And when you look at it, you say the disparity is so wide and so obvious that how is it that we haven't dealt with it yet? That the American public, I can't say that they're blind to it. I'll say that they close their eyes or they turn away from the facts of what is going on with us as American citizens to say that, it's 2014. These rights were fought for, 40, 50 years ago. How is it that we're still in the same place when you look at the prison system and you say 1 out of 3, black male children that are born will go to prison. Why is that still a stat? How is that still a stat in 2014? That 1 out of 3 will go to prison just because of the color of their skin. But when you look at these executives, I mean, we aren't talking about, men on the street who, have a criminal record or was in any type of criminal activity. These are military veterans. My brother, Clinton Stewart, who was my mentor, and, I grew up, I went the wrong route, and I ended up doing a lot of things on the street that I'm not proud of. He mentored me to pull me back from that direction and got me into the IT arena where I can be a viable part of society and have something to offer. Well, you look at him, he was in crypto maintenance in the military. You're talking about he held the highest levels of security in the Air Force, where he's hand carrying secure documents to the executive branch. This is a man that you lock up and say you deserve to be in prison for 9 years because of debt. You look at the other men who are veterans, who've served their country, and their community. And I mean, these are not drug dealers that hung out on a corner that decided one day that they would run some type of scam. These are real, viable parts of society that was going to break the stereotype of what a young black man is. And what happens? The system, our system, basically criminalized the work that they were doing to try to help the country and lock them up in prison for up to 11 years.
So what can people do?
Don,
yeah, go ahead.
I'm sorry. And if I may add to a couple of points that you made, and like Cliff said, you're spot on as far as the summary that you made. And one thing I'll add is that was compounded by the fact that, and we briefly touched on it, but it's compounded by the fact that the 10th Circuit Court of Appeals did not drill down into the inconsistencies in this case. Now, one thing that we've heard, and it's a very sad truth, and that is that, Court of Appeals are not in place to overturn cases. If anything, they are more so in place to affirm the findings of the lower court. Now, that's a sad state of affairs, but we have our team that has been visiting Washington, D.C. has actually heard that come out of the mouth of our legislators. That's number one. On the race issue, when you look at the fact that this case occurred in Colorado, where Colorado has roughly a 4.4% makeup of African Americans, and absolutely prosecutor, Assistant U.S. Attorney Matthew Kirsch played on that with the jury. And like Cliff stated, all of these men, the 5 African American as well as the 1 Caucasian, all of them were highly skilled consultants in the IT field, had been for years before they took a step back to start a company. Now, they gave up a lot in order to do that. But the way it was presented to the jury by the prosecutor, he actually tried to portray the fact that the men did not have the skills, not just from a business perspective, but from an IT perspective. And they also tried to paint the picture that several other people who worked at IRP Solutions did not have the skills. Now, if you are a white prosecutor presenting to a jury of 12 people, 10 of which I believe were two were African American, the other 10 were Caucasian or some other. And if you're presenting that to a jury and they see sitting before them 5 African American men, then, that seed was planted that, oh yeah, they're trying to run a scam.
Right.
They probably don't have the goods.
Right.
They probably don't. And then Judge Arguello would not allow them to drill down and give more specifics about their background. She would not allow them to get into discussions on intent. In fact, Judge Arguello made the comment that your character is not on trial here. Now, we take exception to that because
for fraud, you need intent.
Exactly.
You need
You're calling
intent.
me a criminal.
Right.
You're saying that I am fraudulent. You're saying that I'm not running a legitimate business. You're saying that I don't have the goods. You're saying that I am not skilled in what my business is about. And then you're going to tell me that my character is not on trial? Excuse me?
Well, it leaves the obvious question. If you have a team of scamsters that can come up with this software that $1 billion and $200 million worth of federal contractors can't produce, then what does it say about those contractors?
Exactly. And you know, the definition of a scam is that you're presenting something that doesn't exist and getting money for it.
Right.
That's a scam.
That's the opposite of what happened here.
Exactly. If you have a group of men who are developing, marketing their product for sale, that's not a scam. That's called business.
Right.
That's how business is done. Right. It's totally ridiculous.
And Cliff, Don, this is going to floor you too. Cliff, you got to remember, Agent Smith, sitting in the courtroom, on at least 2 occasions, made the comment. He made the comment in court that if IRP had paid their debt, using the word debt, he said if IRP Solutions had paid their debt, we would not be here. So he confirms the fact that the case is all about debt,
right.
But yet you put a fraud and scheme wrapping around that. So absolutely, we stand firm that the gentlemen were railroaded. The conspiracy was not the IRP-6. The conspiracy was a government conspiracy against the IRP-6.
Okay, so we're almost out of time. What can people do to help support, and what's going on now, and what can people do to support it? Well, what's going on now? For more information about the IRP-6 case, folks can go out to freetheirp6.org, freetheirp6.org. They can get information about the case. They can read up about the guys. They can read up about the company. There's court documents out there as well. We have a letter writing campaign going where we're sending letters corresponding with legislators. We have a phone campaign going where we're calling the Attorney General's office, and that information is out on the website as well. Folks can listen in to ajcradio.com. One of the biggest things, I guess, right now, Don, is the fact that the gentlemen, they have families. They were involved in their community. They have kids. They have wives. They were involved in their church. The holidays are coming up, and then over the last two and a half years, obviously expenses just in maintaining their households have incurred. Had it not been for the support of other friends and family, these families could very well have ended up in a shelter. I mean, like Cliff was saying, his brother, Clint, had at the time, I think Tiffany was 17 or 18 years old, his daughter. Clint was a single parent. The judge took no consideration for what is going to happen to this teenage girl. She could end up on the street. She could end up in a shelter or whatever. Right now, A Just Cause has assisted in setting up a fund on GoFundMe. So folks can go out to GoFundMe and do a search on IRP-6. We have gotten tremendous response as far as donations, and those donations are going directly to the support of the IRP-6 families and their children. Okay, Cliff, Sam, thank you very much, and we will definitely get this out there.
All right, thank you, Don. We appreciate it.
Thank you, too.
Don, we truly appreciate it. Thank you for everything you're doing.
Thank you, too.